We're going to turn now to the ABC News exclusive tonight after Donald Trump was fined nearly $355 million in his civil fraud case. Tonight, New York State's Attorney General Letitia James saying she's prepared to seize Donald Trump's assets, including his buildings, if he doesn't pay the money. ABC's Aaron Katersky one-on-one tonight with the Attorney General.
4 days after a judge ordered Donald Trump to pay $355 million for a decade of fraud, New York Attorney General Letitia James says she's prepared to do everything she can to make sure the former president pays his fine, including, she told us, seizing the buildings that bear his name.
If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
Trump was held liable for exaggerating his wealth and inflating the value of his real estate so banks would give him low-interest loans.
Hi everyone, Adam is here. This is what's happening. Because what we are about to walk through is not speculation, not political theater, not the usual noise that surrounds this former and current president. This is the documented, court-confirmed, legally binding reality of what has happened to Donald Trump's business empire.
In the race for the White House, Donald Trump is comparing himself to Alexei Navalny, refusing to criticize Vladimir Putin as he faces the possibility that his assets will be seized if he doesn't pay the fine for committing business fraud.
This morning, Donald Trump facing a massive $355 million fine, once again comparing himself to Alexei Navalny when asked about his legal bills.
How would you put up that kind of money? Because you have a bond to put up. Even if you appeal, you got to put up escrow money. That's it's a lot of dough.
It is a form of Navalny. It is a form of communism or fascism.
And more importantly, what is still happening right now in real time, under the watchful eye of a judge, a court-appointed monitor, and a state attorney general who has already promised to seize assets if the money isn't paid. We are talking about a fraud finding that has been confirmed by an appellate court. We are talking about business bans that are actively in force.
But first tonight, the breaking news involving former President Trump. Here in New York City, a judge ruling that the former president committed widespread fraud. The judge determining Trump lied for years about his net worth by inflating the value of his real estate portfolio. The judge finding the evidence so overwhelming, they don't need to go to trial. The former president accused, along with his two eldest sons, Don Jr. and Eric. Among the properties the judge found they inflated, his Fifth Avenue apartment in Trump Tower by as much as $200 million, and inflating the value of Mar-a-Lago in Florida by nearly $600 million. In bringing the suit, New York Attorney General Letitia James had accused Trump, his sons, and his business of overstating their net worth by as much as $2.2 billion.
We are talking about a court-appointed monitor sitting inside the Trump organization, watching its financial moves, reviewing its transactions, reporting directly back to the bench. We are talking about loan restrictions that cut off access to the very financial institutions that any New York real estate empire needs to survive. And we are talking about an enforcement machine that is already moving. Judgment liens filed against specific properties, interest accumulating daily, and the very real possibility of an emergency asset freeze that could lock down Trump's financial empire nationwide.
The judge agreeing with New York Attorney General Letitia James, Trump overstated his net worth by as much as $2.2 billion. Duping banks, insurance companies, and other business partners into giving Trump, his eldest sons, and their family real estate business better terms than deserved. Trump has consistently denied wrongdoing and has attacked the Attorney General and her case. But tonight, the judge rejected each of Trump's defenses, calling them bogus and deceptive, and saying at one point Trump's denials were straight out of, quote, fantasy world.
This is not a fine. This is not a penalty you pay and move on. This is judicial control, ongoing, active, permanent. And the appellate court has already made clear. The fraud finding is not going anywhere. The controls are not going anywhere. The only question left is how much money and how far the enforcement will go. So let's pull back the curtain. Let's walk through exactly what happened, exactly what is happening right now, and exactly what is coming next. Because if you think this is just another legal story you can tune out, you are missing the single most consequential judicial intervention into a president's business operations in American history. Let's start with the foundation, because you cannot understand how serious this is unless you understand what was actually proven in court. A New York judge looked at years of financial statements, years of property valuations, years of loan applications, and years of insurance submissions. And what he found was not a mistake. It was not an accounting error. It was not a disagreement between accountants over how to value a building. What he found was a persistent, deliberate, intentional scheme to inflate the value of properties, to falsify financial statements, and to submit those false statements to banks and insurance companies to get better loan terms and cheaper insurance rates than the truth would have allowed. This was not one property. This was not 1 year. This was multiple properties, multiple financial institutions, multiple years of the same pattern repeating itself. And the judge's conclusion was clear. This was fraud, persistent fraud, fraud that was knowing, fraud that was intentional, fraud that had a specific economic purpose, to get deals that honest numbers would never have produced. Now, anyone who has followed Trump's legal battles knows that when a trial court rules against him, the immediate response is to call the judge biased, to call the ruling partisan, to claim the system is rigged. And that happened here. That was the narrative. That was the playbook. But then something happened that changed everything. The appellate court reviewed the case. They looked at the evidence. They looked at the judge's findings. And they did not throw it out. They did not reverse it. They did not send it back with a rebuke. Instead, they affirmed the fraud finding. They confirmed that the evidence supported the conclusion. They kept the business bans in place. They kept the court-appointed monitor in place. They kept the loan restrictions in place, and they sent only one thing back for further proceedings: the exact dollar amount of the penalty. Do you understand what that means? It means the fraud is no longer just the opinion of one trial judge. It is the confirmed legal conclusion of New York's appellate court. It is in the permanent judicial record. It is not going away. No matter what happens in the further proceedings on the dollar amount, that fraud finding stands. And everything that flows from it, the monitor, the bans, the restrictions, stands with it. That is the foundation. That is the bedrock. And on that foundation, an entire enforcement structure has been built. Now let's talk about what that enforcement structure actually looks like, because this is where the story moves from legal theory to real-world consequences. First, there is the court-appointed monitor. I want you to really sit with what that means. A court-appointed monitor is not a passive observer. This is not someone who files a report once a year and then disappears. This is an officer of the court who has been placed inside the Trump organization with direct access to its financial records, its transaction histories, its internal operations. This person is watching. This person is reviewing. This person is reporting directly to the judge on what is happening inside the company. In large civil fraud cases, monitors are given specific authority to examine financial transactions, to identify patterns that raise concerns, and to flag any activity that looks like it might be designed to move assets beyond the reach of creditors. And that authority is not theoretical. It is active. It is ongoing. It is happening right now. Why does that matter? Because when you have a judgment against you for hundreds of millions of dollars, the most obvious temptation in the world is to move assets, to shift valuable properties into family trusts, to transfer money to offshore entities, to restructure ownership in ways that make it harder for creditors to collect. And the monitor's job is to watch for exactly that behavior, to catch it, to document it, to report it to the court. That is accountability. Not the kind that happens in a courtroom once a year. The kind that happens every day, inside the organization, with someone watching who answers only to the judge. Second, there are the loan restrictions. The judge's order restricts Trump's ability to obtain loans from New York regulated financial institutions. And if you know anything about commercial real estate, you know what that means. Real estate is a credit business. You buy properties with borrowed money. You refinance maturing debt with new loans. You use access to credit to manage cash flow, to fund operations, to weather downturns. Cut off access to credit, and you cut off the oxygen that keeps the business alive. The restriction applies specifically to New York regulated institutions, the banks that have historically been the most important players in New York commercial real estate. And the appellate court kept that restriction in place. So even as the dollar amount is being recalculated, even as further proceedings continue, the financial constraints remain. The pressure remains. The judicial control remains. Third, there are the business bans. Trump himself is barred from serving as an officer or director of any New York company for 3 years. His sons face similar bans. That means the people who built this organization, who ran it for decades, who made the decisions that led to the fraud finding, are now prohibited from holding leadership positions in New York-based entities. The organization is being run under court supervision, with people who are not subject to the bans, but with a monitor watching every major move. So let's pause here and take stock. We have a confirmed fraud finding. We have a court-appointed monitor inside the organization. We have loan restrictions limiting access to credit. We have business bans removing the family from leadership roles. And all of this is active, all of this is ongoing, and none of it depends on what happens with the dollar amount in further proceedings. This is not a penalty you pay and move on. This is judicial control. Continuous, permanent, watching. Now let's talk about what comes next, because the enforcement process is already moving, and it is moving in a direction that could lead to something truly dramatic. The Attorney General of New York has made her position very clear. She has said on the record that if the judgment is not satisfied, she will seize assets, not threaten, not negotiate, seize, and she has already started the process. Judgment liens have been filed against specific properties in specific counties. Those liens are public records. They are filed, they are active, they are waiting. When a lien is filed against a property, it means the judgment creditor has a legal claim on that property. The property cannot be sold or refinanced without addressing the lien, and if the judgment is not paid, the next step is foreclosure, physical seizure. The property taken, sold, and the proceeds applied to the judgment. That is the path we are on. The liens are filed. The interest is running. The Attorney General has made her position clear. And the only question is whether the judgment gets paid before the foreclosure process reaches its conclusion. But here is where the story gets even more interesting. Because there is another tool available to courts in large civil fraud cases that goes beyond liens and foreclosure. It is called an emergency asset restraint order. And it is exactly what it sounds like. When a judgment debtor is taking steps to move assets beyond the reach of creditors, transferring properties, moving money offshore, restructuring ownership in ways that make collection harder, the court can step in and freeze everything. Not just the properties that have liens filed, everything, nationwide. The court can issue a temporary restraining order or a preliminary injunction that prohibits any transfer, any encumbrance, any dissipation of assets until the enforcement process is complete. This is not a new legal theory. It is not a creative interpretation of the rules. It is a standard tool in civil fraud enforcement, available under existing civil procedure rules, used whenever there is evidence that the judgment debtor is trying to make collection impossible. And here is what makes this case different from almost any other civil fraud case in American history. The court already has a monitor inside the Trump organization. That monitor has access to internal financial records. That monitor is watching transactions, watching transfers, watching for patterns. If that monitor sees anything that looks like asset shifting, anything that looks like an attempt to move money or properties beyond the reach of creditors, that evidence goes straight to the judge, and that evidence becomes the foundation for an emergency asset restraint application. So the question is not whether the legal tool exists. It does. The question is not whether the court has the authority to use it. It does. The question is whether the monitor will find evidence of asset shifting that makes the application necessary. And that is the piece we need to watch, because the fraud finding confirmed that Trump's business operated for years by inflating valuations and falsifying statements. That is a pattern. That is a documented history of financial deception. When you combine that pattern with the pressure of a massive judgment, the daily accrual of interest, the liens filed against properties, and a monitor watching every move, the risk of asset shifting is real. And if the monitor catches it, the emergency freeze becomes not just possible, but likely. Now let's talk about the tax angle that connects all of this to Washington, because there is a political dimension here that affects how the story unfolds. House Republicans are trying to pass a tax bill. Their margins are razor thin. They cannot afford to lose more than a handful of votes, and there are members from high-cost states like New York, New Jersey, and California who have specific concerns about how the tax bill affects their constituents. Those members have leverage. They can demand changes, compromises, concessions in exchange for their votes. One of the issues that matters to those members is the state and local tax deduction, the SALT deduction. And as the tax bill moves through Congress, the negotiations over SALT are one of the early battles that will determine whether the bill can pass. So, even as the civil fraud enforcement proceeds in New York, even as the judgment liens accumulate, even as the monitor watches for asset shifting, there is a parallel political story unfolding in Washington that affects the margins, the coalitions, and the votes that determine what legislation can pass. It is a reminder that accountability happens on multiple tracks. The judicial track is moving, the enforcement track is moving, the political track is moving, and they are all connected because the people who have leverage in one arena often use it to shape outcomes in another. So let me give you 4 points to take away from everything we have covered. 4 things to remember, 4 things to watch, 4 reasons why this story matters more than almost any other legal story involving this former and current president. The fraud finding is confirmed. The appellate court looked at the evidence, reviewed the trial court's work, and affirmed the conclusion that Trump engaged in persistent fraud by inflating property values and falsifying financial statements. That finding is now in the permanent judicial record. It is not going away. No matter what happens in the further proceedings on the dollar amount, the fraud stands, and the controls that flow from it stand with it. The controls are active. The court-appointed monitor is inside the Trump Organization right now, reviewing financial transactions, examining records, reporting to the judge. The loan restrictions are in place, limiting access to credit from New York regulated institutions. The business bans are in effect, removing Trump and his sons from leadership roles in New York companies. This is not a future threat. This is present reality. The enforcement is moving. Judgment liens have been filed against specific properties. Interest is accruing daily. The Attorney General has committed on the record to seize assets if the judgment is not paid. And the legal tools for emergency asset restraint are available if the monitor finds evidence of asset shifting. The path from where we are to a nationwide freeze is not theoretical. It is procedural. It is documented. It is ready. Here is what to watch. Watch the monitor. What does the monitor report about financial transactions, about transfers, about unusual patterns? That evidence will determine whether an emergency freeze application is filed. Watch the further proceedings on the dollar amount. What final number emerges and how quickly? That number will determine how much pressure is on the enforcement timeline. Watch the Attorney General's moves. Does she request execution on the properties with liens? Does she push for foreclosure? Those decisions will determine whether the enforcement stays at the lien stage or moves to physical seizure. And watch the broader financial scrutiny. The fraud finding has opened doors. Investigators, journalists, and creditors are looking at offshore structures, intercompany transactions, anything that might reveal asset shifting or financial manipulation. Here is the bottom line. The judge struck hard. The monitor is watching. The liens are filed. The interest is running. And the enforcement trajectory is moving toward the most dramatic tools available. Tools that could freeze Trump's financial empire nationwide if the evidence supports it. This is not a hypothetical. This is not a prediction. This is the documented reality of a confirmed fraud finding, active judicial controls, and an enforcement process that is already underway. The appellate court has spoken. The fraud stands, the controls remain, and the only question is how far the enforcement will go. So stay tuned, because the further proceedings are active, the monitor is watching, and we are going to be right here covering every development as it unfolds. If you are not subscribed yet, hit that button right now. Drop a comment below and tell me what you think. Does the court monitor ever report the specific evidence that would support an emergency nationwide freeze, or does the enforcement remain at the lien and accrual stage through the entire process? I want to hear from you. I will see you in the next one.